Thank you so much for being in attendance. First order of business is the adoption of our minutes from the last meeting. I'm sure that everyone has had a chance to read those minutes, and if there are any discrepancies or changes that might need to be made, we can raise them now before a motion is made to accept the minutes as produced.
Motion to accept.
Okay, anyone second that?
Second.
All right, all in favor?
Aye.
All right, so carried. Now we're going to have a brief report. The agency is moving in a forward direction. Grateful for that. There are a lot of exciting things that are happening, and there's a lot of work that we yet have to do to make sure that things stay on track. And I'm certain that as the days and weeks progress, that a lot of those things that may be off track will be put back on track, and we will continue the work of serving the citizens of New York City and the complaints that are filed with the agency, and be productive in that respect. We, of course, had an executive session today that discussed some of the things that we as a board are trying to really move forward as it relates to cases that are being disposed of or categorized, and we certainly hope to discuss more of that in the public meeting on today. Now we're going to have the report from the Executive Director.
May I make a correction, Mr. Chair? There was the operation committee this morning.
I'm sorry, Operations Committee.
Thank you, Bishop. Good morning, everyone. This month, in April of 2014, the CCRB received 486 complaints. This is 52 complaints fewer than the same period of 2013, when the CCRB received 538 complaints, and you can see this referenced in page 5 of our report. During the first 4 months of 2014, the CCRB received 1,809 complaints within its jurisdiction. This is 230 more complaints than were received in the same period last year, when we received 1,570 complaints. Year to date, we've had an increase of 15% of our cases since last year. However, it should be recognized that these numbers reflect cases that fall within our jurisdiction, and as investigations proceed, sometimes those numbers can fluctuate to reflect that cases are then not within our jurisdiction. The board closed 553 cases in April and a total of 1,629 year to date. In the first 4 months of 2014, the board closed 630 full investigations, including 99 substantiated complaints, and year to date, our substantiation rate is 16% of fully investigated cases. Again, what we have discovered, and I want to thank the IT department for working so hard to help us with this, is that board closings of cases can fluctuate in terms of month to month, so sometimes that number may look different than what we presented the month before, but that is an issue that we are working on and we will address. In April, civilians and officers mediated 15 cases. Year to date, civilians and officers have mediated a total of 45 cases, and that from January to April of this year, the board has closed 42 cases as mediation attempted. The detailed monthly statistical report includes 2 forms of reporting dispositions of CCRB cases. The first report shows the truncation rate, that's on page 8, and the second report shows the case resolution rate, which is on page 9. From January to April of this year, the updated truncation rate, excluding cases closed as complaint withdrawn, was 50%. In the same period from last year, that rate was 59%. But if you look at page 9, the case resolution rate from January to April 2014 was 44%, and in the same period of this time last year, it was 30%. The agency docket at the end of April 30th of this year was 2,545 cases. This is a 5% decrease over the open docket from March of this year, when we were at 2,690 cases. And if you look at page 1 of our report, by date of report, 95% of our open investigations stem from complaints filed within the last year, and 65% were filed in the last 4 months. Out of the 2,545 open cases, 321 were awaiting panel review, which is 13% of our docket. 1,964 were being investigated, 77% of our docket, and 268 cases were in the mediation program, including mediation attempted cases pending board approval for closure, which is a total of 10% of our docket. That's reflected on page 2. By date of incident, 15 cases in our open docket are 18 months or older. This was 0.6% of our open docket, and in March of this year, that was 21 cases. Breaking down those 15 cases as follows. 4 cases are pending board review, of which 2 were returned by the board for the further work. 1 was filed late, and the other was late because of delays in receiving police department documents. In one of those cases, the statute of limitations crime exception applies. Of the remaining 11 open investigations, the SOL crime exception applies to 6 cases. 4 cases are on DA hold. 5 cases were filed months after the date of incident. 1 case was reopened 7 months after the first closure, and 1 case was late due to investigative delays. In March of 2014, the police department closed 5 substantiated cases involving 7 officers. 2 of these officers received command discipline A, 3 officers received instructions, and the department declined to prosecute 2 cases. 1 case, a substantiation with charges, was referred to the police department prior to the implementation of the APU, and 6 cases, all of which were recommendation of CDs or instructions, were sent after the implementation of the APU. In March of this year, the disciplinary action rate was 71% and 76% year-to-date. From January to April of this year, or from year-to-date, the police department declined to prosecute rate is 24%. That's reflected on page 30 of our report. In April of 2014, 16 cases were substantiated by the board with a recommendation of charges and specifications and were added to the APU docket. At the end of April, the open docket of the APU was comprised of 192 cases. Of these cases, 3 had dispositions modified by the police commissioner and were awaiting recalendering. 12 cases had guilty pleas entered and were awaiting approval by the police commissioner. In 2 cases, the trial verdict was rendered and is awaiting approval by the police commissioner. 13 trials have been completed, awaiting verdicts. 9 trials were commenced but not completed. 34 trials have been scheduled. 22 cases are calendared for court appearances. 69 cases are awaiting their initial court appearance after charges have been served, and 6 cases charges have been filed, and the remaining 22 cases are awaiting service. In the March disposition report, there were no final dispositions of APU cases reported. This month, or in April 28th of 2014, the Executive Committee, Commissioners Martin, Liston, and Taylor, as well as Commissioner Simonetti, and members of the staff and I met with Deputy Police Commissioner Susan Herman to discuss mediation and her collaborative policing unit and how we can work together to enhance our mediation program for civilians and be more collaborative in our process. She had some excellent ideas for the board in terms of how we can move towards a more dialogue-minded mediation program versus a formal, more litigious mediation program. One of her concerns, what was good about the meeting was that a lot of her concerns were already incorporated. And I have to thank the executive committee for their hard work in preparing us for the meeting and articulating how our agency does incorporate a lot of the suggestions she made. One of the ideas was to restructure our mediation agreements to look less like legal documents and more of a dialogue type of document. That's something that we've presented to the board and something we can consider. They wanted to make sure that we are keeping these matters confidential, which of course we are, and we ensure that through our confidentiality agreements. She also wanted to make sure that we have a high caliber of mediators and that they're continually trained, and she actually volunteered to help us with the training with them, so that's something that we've been working on. But again, the executive committee set up a great meeting in terms of working together to make a commitment between the NYPD and us to further increasing the number of cases going to mediation where the parties want to and making them as successful and fruitful as possible. And I have to thank Lisa Cohen for all her hard work on this as well. In terms of the agency operations, as you can see, we have repainted some of the areas, so that is a positive. I also have to thank Rob Rodriguez, one of our team managers, for his hard work. He's a great supporter of our softball team, and he's been working hard to encourage the agency and all of our staff to come to the games and participate, as well as a Yankee Met game that we went on yesterday, so it's a positive that the agency is moving in a good direction and working together. Any questions?
I have a question about statistics.
Okay.
And the APU in particular. When the APU tries a case that, say, involved 2 officers in the same incident, does the APU try both officers at the same time, or is it 2 separate trials?
It would be the same time.
At the
unless
same
there was
time?
something-
They're joined? Okay. That's good. And then, am I reading this right, that last month, the police department came back, I think, with 7... The police department closed 5 substantiated cases involving 7 officers,
Yes.
but we're sending upwards of 20 officers a month, at least, to the APU for charges. Isn't that right? At least last month, I think. I counted, but it's hard to count. I think it's about 20 different officers were given charges, quote unquote.
One of the things that we're finding is that month to month, some of the statistics are being reflected, I don't want to say inconsistently, but in ways that we need to fix within our computer system, because a panel might meet in one month and then meet again in another month.
Yeah.
And so in terms of how those numbers are being projected in our reports, it may show, it's hard to give a month-to-month assessment of what's going on with the DAO because those numbers could change.
Yeah, I understand that. Because, I mean, sometimes my panel will meet twice a month instead of and skip the next month. I understand that. But it does seem to me, regardless, we are still sending significantly more cases for charges than the police department closes each month.
Well, one of the things, I have the action items that we discussed last month, and in terms of following up on some of the things that the board members presented, that was certainly a concern that you had presented and the other board members. So what we are doing is we have started reconciling our cases with DAO. We've sent them over a list of all of the cases that we have, that we know we've sent, where we don't have closure. They have been working with us to send us cases back, to give us resolution on those cases that have been resolved. And at this point, we actually are down to a very small pool of numbers
Great.
that they have open. So I think it was just a matter, what we've instituted now is on a monthly basis, we will do reconciling with DAO and then be able to report back to you how many cases they have in their open docket that are CCRB cases.
Wonderful. Good. Thank you.
One of the other things that came up last month, Commissioner Simonetti wanted us to circulate to the board a list of cases that were eligible for mediation and those that weren't. We did that last month. All the board members received that by email. So it gives us a greater opportunity to discuss whether or not you want to expand that list, whether that list is appropriate, and that's something that the board can discuss. Commissioner Grant wanted to set up a procedure to have employee feedback in terms of exit interviews when people are leaving. We have that proceeding. We do that with our HR director, and then I myself also meet when the person is leaving to discuss with them how the positives and negatives and what they think we could do to improve our operations goes. So that is something that we have implemented
Do
since
we have
last
a
year.
board member as a part of that process when employees exit?
We don't, but we could. That's a good
So I think
idea.
that someone from the personnel committee should probably be on that exit interview process. I don't know how you guys feel about that, but I think that you know, to have it. Huh? It's not?
It may not be feasible to have a board member on it initially. I think if there's some significant information that needs to be escalated, then a board member could be involved. But I think feasibly that can happen pretty quickly. There's a lot of turnover at the agency. I just don't know if we have the resources to do that. I certainly think I see where you're going, right? If there's some issues that we need to be made aware of, I think the way to address that is to have a significant number of people involved in that exit interview. Traditionally, you'll have your head of HR. You'll have your executive director. You might have someone from the legal and on the employment side. We're looking to fill our GC position, but we can work out who would be on that group to do the post interviews.
Is there a document that one fills out that is available to review?
Yes.
Like in post the exit of a staff member?
Well,
We do. We have an exit interview sheet that the employee fills out, explaining the positives, negatives, what their experience was, how they would improve it, why they're leaving. It's a 2-page form, and it gives them ample opportunity to give feedback. They also have sometimes added to that form. They add their own pages, and they write out what they want. So we could certainly provide that to the Personnel Committee
Yeah,
for your
I haven't
review.
seen the form, so.
I mean, just as long as there's some kind of record from the employee, I think it's just our responsibility to make sure that if there's exit interviews done, that it's made a part of the public file for that employee.
The only thing I would say there, my lawyer had is sort of going is, and I want to get advice from, appropriate counsel to the board, just to make sure that that document is what it should be and can't be misconstrued into anything else. But I hear what you're saying, and we'll look into it.
I don't know that that should be a public file. You just...
When I say public, I mean,
What? Public means public, right? And it's available to the public? Is that...
not the public, but I mean in terms of the
What
board.
public? Us?
Yeah,
Just us?
the members of the board, yes.
Okay. Because I don't think that that should be a public document.
No, I mean, that's why you don't talk about personal issues in public.
Yeah, I think.
No, but the exit interview document I'm talking about
Right.
specifically, I don't think that should be a public doc. Because suppose the person's going to be very candid with the people who are doing the interview and say, there's a deficiency here. You got to plug this hole. You're not doing it right. You know what I'm saying? And I don't think that should be available. Now, what information do we give a prospective employer who calls the agency and says, did Simonetti was in your employ for a couple of years? You just give the dates?
That's correct.
That's it.
Only the HR person speaks to that.
Is that what you give, that the extent of your information?
That's correct.
You don't comment on?
No.
Okay, good. I mean, that should be the policy.
It is. And the only person that speaks to prospective employers is the HR. Any calls that come in, if anyone else were to get them, they would refer them to the HR department for their questions, but HR has been directed, and that's their policy.
And is that documented? Is HR document who calls?
Oh, well, I can tell you that the current HR director does. I mean, I don't know what the policy was before I got here, but I can tell you that, to my knowledge, I know that the new director does that.
And the new director has been on board how long now?
January.
Since January? And so no one else has talked to prospective employers relative to past employees?
Not to my knowledge.
Okay.
Another issue that came up, we were talking about tolling the statute of limitations on DA hold cases. Commissioner Simonetti suggested we discuss this at the meeting with Susan Herman. We had a long meeting and we had a lot of topics that we never got to that one, but it is something that I'm hoping that once DAO appoints a new deputy commissioner, it's something we can discuss in terms of how we're handling those cases. Commissioner Grant had suggested that all new initiatives raised be documented and followed through, so we're working on that. So that's something that we're moving on. The complainant satisfaction...
Just to be clear on that, this again goes back to my point that, decisions are made, we talk about doing these things, action items are made, and we end up coming back to it at the end of 3 months. And so what I've asked Tracy to do is to detail what we've discussed in the board meeting, aside from the minutes, but just the action items. And then we can track those action items and see what's being done to move it forward. So thank you, Tracy.
Thanks. Commissioner Simonetti had mentioned a complainant satisfaction survey, and that is something that Susan Herman's working on for the NYPD. Mediation already does that, as does outreach. So I have to thank Carl Mace Johnson and Lisa Cohen for showing me. They actually have given us some samples. We're trying to incorporate it for the investigative side. So it's something that we can work on with the operations committee. Once we get some drafts together, we can work on whether or not we want to do satisfaction surveys once a case is completed, when we send out the letter informing both sides of the results. But that's something that the board will get to you, and we can work on that as a project. Then there were a couple of items that came up. We've been talking about the substantiated cases. We put together in the packet some more information about the total substantiated cases in 2013, and we're breaking that down for you. And we had discussed the idea of the entrance of visitors and getting IDs and photos and such. We've been working on that. The building has committed that they will not take pictures of people coming in on a public day, and that they routinely, weekly or bi-weekly will erase all pictures taken. But it's something that once we get our own exit, which we're entrance and exit we're working on, and that should be done in the next probably 2 months, where we'll have more control over it. But right now, and we've been able to confirm today that they did not take photos of any of the public coming in today. Other than that, I think that addresses the issues that came up last month.
Yeah, at the Operations Committee this morning, we were discussing administratively closed cases, and the members of the board that were present suggested that we bring it up to the entire board, and we adopt a resolution to do it as a pilot program for 6 months, beginning in June and lasting until the end of the year, to take a look, to get a better understanding of what that's all about. So that's the discussion we had about administratively closed cases, and the members that were there agreed that we should bring it to the full board and then have to decide by a vote of the full board. So if you want to put it in the form of a resolution.
Tony, can you just give just a little bit more bandwidth on it so the members that were not here can?
Yeah. The administratively closed cases, as Tracy points out, we get a lot of those cases that come from IAB, and they're not complainant generated in most cases. Most of those cases are a blurb that they got, in some cases, from reading a newspaper article, and then the department will generate a blurb to us saying so-and-so. So it's not, in most cases, complainant generated. So what they do, they get those cases, they take a look at them, they reach out, see if they can talk to someone, particularly the complainant, to find out if they want to go forward with the case. Or no, excuse me, you wait 21 days.
No, we first reach out.
You reach out, then wait 21 days. And after 21 days, if they haven't heard back, they'll attempt on several more occasions to reach out to try to get the complainant. At that point, if they're unsuccessful, the case is administratively closed. Our best guesstimate is that there's going to probably be somewhere between 100 and 125 cases a year. So it's not a large number of cases, though but it does impact somewhat on the docket. So that's basically what the resolution is. But the 6-month trial period will give board members an opportunity to take a look at it, and then we can always make changes as we go along. This is not cast in granite.
And I would like to add also, Tony, that the cases which are sensitive, excessive force, all those are not included in this category.
Right.
Yeah.
Essentially, what the Operations Committee is proposing for the full board to vote on is in those cases where there's no complainant, where the complainant has never contacted us, we did not get notice from the complainant, we got notice either from IAB or some other NYPD department, we will reach out to that complainant, we will try to call them, and we will send a letter indicating that they may be the victim or witness to police misconduct, and that they can file a complaint reaching us by all the methods that we have. We will then wait 21 days. If we've not heard from the person and not received any communication, we will send another letter saying that we need to hear from you if you're wishing to proceed, but we're going to administratively close the case until we hear from you and you have an 18-month window to communicate with us. Once the investigator and the team supervisors have reviewed those cases and ensured that they're not serious injury, that there's not excessive force, that they're not sensitive cases, then they will be put into a panel where the Deputy Executive Director for Investigations, Dennis McCormick, and/or I will review them, make sure that they still fit that criteria. If they do fit that criteria, they will then be sent to a panel of the board members, and that'll be a rotating panel each month, where the board members will get the case, review all of the communications, and determine whether or not that case should be administratively closed. And as Commissioner Simonetti pointed out, if any one panel member feels the case should go back for further review or for further information, it will be sent back to the team for further investigation. If the panel does not vote to administratively close it, then the case will be sent back and we'll make more attempts. But these are separate from truncated cases or complaint withdrawn. These are cases, truncated cases are cases where there's been some communication with a complainant, And then either that, if they become unavailable, they're uncooperative, they're withdrawn in some fashion. These are strictly cases where we have never heard from the complainant. So it's not a big number of our cases, as you pointed out, but again, it would resolve. Right now, we have about 60 cases in this posture, and we've had these cases waiting for about 5 months. So that's where we figured out it's on average 12 cases a month. And the panel, the board can determine how the panel would obviously be one designee from each mayoral, city council, and police, and it would be a rotating panel that would ultimately decide that those cases are administratively closed. So the resolution is to adopt this.
Procedure. I move to
Procedure.
adopt the procedure.
I do.
I second.
All in favor?
Aye.
Aye, so carried.
Thank you very much, Commissioner.
Also, we move into committee reports. I guess Dave Liston is not here today, had an emergency. But if there is a report from the APU, maybe Laura, you can give that?
Sure. I would just say that the APU has released our quarterly report for the first quarter of 2014. It's part of the packet that was distributed publicly today. And, I just want to commend the unit. There's a lot of hard work that's been embodied in those numbers, both on the trials that we've taken in terms of outreach that the unit has done. I'm very proud of the work, and I'm grateful to everyone for all the hard work you put into those cases.
Thank you so much, Laura. And I too want to congratulate the APU unit and the work that you guys, your team is doing. It's really valuable work and very good work and very intense work. So thank you so much for the job that you guys are doing. Any other committees have reports?
I can report on the investigations committee. I've worked with Dennis on the DA Holds issue that was raised last month, just to make sure that everything is in order with that. There are 1 or 2 cases where the statute of limitations is approaching, but none imminent. And I'm working with Dennis to make sure that the right decisions are made in those cases. So we're on top of the issue to the extent there was any worry last month.
Apropos of that, there was a very interesting case in the press, so we certainly can discuss it. The case of the 2 detectives on duty in Queens, assigned to Brooklyn, in Queens, following up on a robbery investigation, if I understand it correctly. And it winds up, one detective discharges his weapon, and he injures his partner. Now, if you read the follow-up stories to that, you'll notice that the shooter, Poggi, submitted his application for retirement. Did anybody catch that? Does everybody understand that there's a 30-day calendar, a 30-day waiting period? You cannot go into a police station as a police officer or anybody in the police department and tell a desk officer, I'm retiring, effective right now. That doesn't work. The department has 30 days to take a look at you, to make sure there are no criminal activities pending, that there are no serious charges pending, and that's been that way for many, many years. When I first came into the police department many years ago, we didn't have that provision. They have that provision, and it's a built-in safeguard, and thank God they have it. And it's interesting because it appears that they're going to bring him up on charges very quickly. And it happened in the Lavodi case, the case that I cited a couple of times here. Similar kinds of thing with the chokehold, with the Baez case where the young man was killed after Lavodi applied a chokehold. And we brought him up on charges. He had applied to vest from the department. I think Poggi is a different case because he has over the 20 years, so he's eligible to retire, not to vest out. So that's an important consideration. So the department is going to bring those charges within the 30 days. And they'll come up with a disposition. And I don't know, I could guess at what the disposition could be. I don't want to venture a guess. But they could give him a monetary fine. They can give him a reduction of all his leave. They can take that money away from him, or they could fire him. So it's going to be interesting to see, but there's that safeguard built in. and that's important. And very kind of similar to also the DA hold. One of the things about the list of things that are not mediable, and the one thing, and I've been saying this, preaching it for 17 and a half years of this board, that gun pointed should be a case that's eligible for mediation. And I'm sorry that most of the board members were not at the meeting with Susan Herman, because she absolutely feels that we should widen the cases that we're putting into mediation. And I couldn't agree more. And the one that jumps off the page here that is not eligible for mediation is the gun-pointed case. I have to tell you a personal story. My partner was killed in 1964. He had the bad guy up against the wall. He had his weapon out. He had the guy. He's going to be in the process of cuffing him. The guy just committed a robbery of a retail establishment. And the guy said to him from eyewitnesses that were close by, hey, listen, you got me? Just relax. And he did relax, but he had the gun pointed. He did relax. The guy turned around, shot him right between the eyes and killed him. So I feel very strongly about guns being pointed at people. The weapon is a tool to a policeman. And I'm not going to second guess anybody, particularly if they're 2 or 3 o'clock in the morning and they're stopping a vehicle that maybe have 4 or 5 people in the vehicle. You don't know what you have in that vehicle. By the way, more cops get killed or injured making vehicle stops and responding to domestic violence disputes. That's a fact throughout the United States. So I'm not going to question or second guess cops if they feel threatened. And I noticed we're allowed the gun withdrawn, you're allowed to mediate, but the gun pointed, you can't mediate. It doesn't make any sense to me. If I'm going to take my weapon out, let me just tell you very clearly, and I think you're a bad person, that gun's going to be pointed right at you. Okay? So I believe that those cases should be eligible for mediation if everything else being equal. That's the one that jumps off the paper. Force cases. There are a lot of force cases that we should take a look at that should go into mediation. And I think our discussion with the Deputy Commissioner was very clear. I mean, she says there's very few cases that couldn't go into mediation. And I kind of agree. So, I mean, that one jumps off the page.
So Tony, the mediation committee, the mediation unit, and members of the board and the staff, for that matter, will take a look at cases that can be mediation eligible. The gun drawn versus the gun pointed, there's too much of a hairline difference, and I absolutely agree with you. I think that for me, mediation is a tremendously important tool. It shortened the times when the complainant could have a conversation with the officers, and I think that that complainant does not have to wait 6 months to 3/4 of a year to have that conversation. I think this is absolutely valuable, and it can be a teaching tool for some officers, and it could be tremendously powerful for the complainant, because that's probably the first and only time that they would have a level playing field where they can discuss what actually occurred.
For what it's worth, I agree. I haven't, I don't know why the line was drawn. I'd like to hear that if anybody has a memory as to why certain things were placed on the not allowed to mediate list, just to hear the rationale. But Mr. Simonetti, what you said resonates with me very much. So for what it's worth, to me at least, if we had to vote right now, I would vote in the same way I think you would.
Well, we're probably going to give you more cases to consider.
Yeah.
And all will be determined not helter-skelter, but for a good, justiciable reason why they should be mediation eligible as opposed to ineligible.
And also, Commissioner Jules, with the cases that are eligible for mediation or given to the mediation committee, they're looked at and scrutinized
Right.
to see if they actually qualify. So I mean, I think that in the gun drawn, gun pointed, I agree with you, Tony. I think that based on the circumstances and the conditions of that particular interaction, it could or could not be eligible for what we're calling now mediation, and be a great opportunity for dialogue to begin. I also think on the point of mediation, that in our meeting with Susan Herman, she brought out that, and of course she wrote some of the original material for the mediation committee years ago, right? I think that, focusing it more on not being as combative as it has sometimes been between the officer and the complainant, and refocusing it so that it is a conversation of respect and a dialogue, and not an opportunity for a civilian to beat up on an officer, and then not an opportunity for an officer just to sit there without any concern or compassion about what this collaborative discussion is about. It is very important. So I think that it would be I don't think that it's so much of the charges or the actual interaction that should disqualify, but the attitude and the willingness of the officer to participate, no matter what the particular charges, and the civilian to be able to understand the civility of coming together and have a dialogue. So I think that's important. So I think that makes more cases, eligible when you have, and I think moving the process up, and I think we talked about that, rather than letting it lie out 6 or 7 months, because the officers are dealing with hundreds and hundreds of stops and cases. And the sooner you begin the process of dialogue, interviewing the officer to find out if that is something that he's amenable to, and understanding the dynamics of it and the benefits of it for the officer and for the civilian, is important. So I think that gives us more bandwidth to be more flexible with gun drawn, gun pointed, and things that may seem more egregious to us in the past in terms of not allowing it to be eligible for mediation, especially some divorce cases as well.
And to further encourage officers to participate in the mediation/dialogue program, whatever information is derived through that conversation, through the mediation process, it will not be used in future proceedings. That will kind of lower the suspicion on the part of a lot of officers, because they believe that if they participate in mediation, it may come back to haunt them.
Right. And I think a campaign, an exhaustive campaign to the police department and the rank and file relative to the benefits and value of mediation or having a conversation with someone that they had indifference with is important. I think that marketing it is going to be very, very important. And once they have a level of trust, I think what was brought out in our meeting with the Deputy Commissioner was that once you have a few officers that actually participate in the process and they're satisfied that, information is being destroyed, on the spot, no notes are being tabulated and taken out of the room, and everything that happens in that room stays in that room and is extinguished when it's finished. When that word gets out, I think, to the rank and file, more people would be interested in participating in that process. All right.
I think we've gotten the cooperation of all the unions except one. There's only one union that represents detectives that's been stonewalling us. All the other unions are on board. And I mean, that's the vast majority of people that come here for cases.
And we have seen an increase in their numbers as well. They are a small percentage of our cases involving detectives, and even that number, in terms of the total number, there's very few cases involving detectives when you look at the grand scope of our cases, but the numbers have improved when it comes to detectives participating in our mediation program, so that's positive.
And Commissioner Herman also has agreed to speak to them personally, the Board of Officers of the DEA, to see if they they would get on board with that and talk up their program amongst the membership, talk up the mediation program. So hopefully that'll go along. PBA is on board. They're completely on board with this. And I guess they're the vast number of our clients, right? PBA members.
Witnesses.
All right, are we finished with that particular committee? Any other committee reports? All right, if not, we're moving on to old business.
I just have a question about something Tracy said. I'm not sure I followed. You were talking about pictures from people coming into the building when...
Yes, typically when you come into the building, their policy was that you'd have to show ID, and then they would take your photo.
Right.
And then you'd be allowed in. They basically, essentially, they take a
Like every
printed
building.
picture, and then they use that to scan it to allow you in. There have been concerns presented that some of the people coming into the building are offended and are uncomfortable with being taken pictures of, because we are a building from law department, our agency, a concern that NYPD would possibly get those pictures, or that they would be stored in some type of, database. So there's been concerns, and we're addressing them.
Okay.
I had the same kind of feeling as you had, because I think, most buildings in New York City, be it a city building or a non-city building, for security purposes, they take
Exactly.
pictures.
I guess you have to balance the security, that the building has to be confident that security is still at whatever level they decide is necessary to protect everybody in the building, staff on this floor and any other number of floors. But I suppose what you're saying is that if they take pictures, it will dissuade complainants from coming in?
There are complainants that are concerned that they might not
Don't
want to
we
come
take,
in.
when a complainant comes in, don't we ask for ID?
We do, but that they consent to that, and that's something, in order to get into our public sessions, this is
Yeah.
supposed to be for the public.
Oh, so for
And-
this session?
Yes,
I see, so it's not just a complainant, it's for this session, which happens to be videotaped.
in particular.
We're not going to take the pictures, okay. I would just want to make sure that the security, I just wouldn't want this complaint to have been instituted, a policy to have been instituted without the building or us taking into account whatever security, I'm not a security expert, but whatever security the building or the building security decides necessary. I mean, it's not just us in the building, it's a lot of people in the building.
Well, you know what, maybe
I
this
just want
was...
to make sure that's balanced. That's my only view.
But people are still showing ID
Yeah.
in terms of getting in, and the building has a right to obviously be concerned about our security, as are we,
Yeah.
of course. But the idea that there could be some storage of a database where people's pictures are held and then potentially used by other avenues, other agencies, I can understand why citizens might be concerned about that. So we're trying to balance out the interests of the security versus making sure that
I just
people
wanted-
don't feel, we don't want people to feel that they don't want to come here, that they're making a choice between having their privacy rights be violated to come to a public meeting
I
versus...
understand that. I'm just suggesting that the balance has to be done. And it sounds like it was.
And when we have our own entrance, how does that work? That would work.
We're not going to take photos of people at the entrance when they come for public meetings, but of course in investigations, people who are coming here for investigations, we do ask for ID. We've talked about the different levels of ID, whether or not you can show a school ID versus a government-issued ID. And again, the idea is to protect the security of everyone here, but ensuring that we know who these people are as well, so that we don't have any issues with identification of witnesses or complainants.
I might want to add that Jay-Z might have something to say about this as well. Any other old business?
On old business, I think it was last month, it was raised that someone from legal or a lawyer had written a memo about when it was appropriate, I don't have it in front of me, but essentially to frisk somebody, when it was appropriate for a police officer to frisk somebody in the context of issuing a summons. I obtained the memo, I read it. I have to say it was very well written just from a lawyer's point of view, regardless of whatever the conclusion is. I want to say that. But I do think to the extent that there was any thought or push for the board to adopt some sort of policy, some sort of generalized policy about when a police officer can frisk in that context, I don't think we should engage in that discussion, because we are not a court. we're not a policy-making body where we tell the police department what to do. All we do in our panels is look at the specific facts and decide whether or not any number of the FATO allegations are proved, substantiated or not. And I think that the memo, well, you perhaps could read it as being a very generalized memo. I think it was meant in the context of that case, having read it, and not as advocating a policy. And so to the extent there was any desire for us to issue a policy, I don't think that'd be appropriate. I think that's more the province of court. And so regardless of how I personally might feel one way or the other, I'm not saying I do agree with it one way or the other, I don't think we as a board should be pronouncing policy or law like that. It's just not our role.
Just to be clear, I think that the reason why the memo was circulated, and you're right, was based on a particular case that we were reading, the panels were reading, and I think that the whole purpose was that to find out what is the extent of the law as it relates to the procedure of executing a stop, question, or frisk, or a frisk in when a person is in custody or not in custody, or the dynamic centered around that, so that there can be impartial adjudication of those cases. Not for us as a panel, a board, to make policies about what the police department should or should not be doing.
I agree.
So it wasn't there.
I agree. I just know that there was some discussion last time about whether or not it was. So I'm agreeing with you.
Okay. Any more old business or any old business? New business.
I do want to raise one thing. It goes to our job to issue sort of policy reports or recommendations.
Is this new business or old business?
It's new.
Okay.
I've seen in my panels at least some case, without commenting on any specifics, some cases where there's some sort of altercation, and typically a younger person takes out his or her phone and starts videotaping it. And the officer, maybe rightly from a human point of view, doesn't want to be videotaped. And they react one way or the other. Sometimes, perhaps in my view, a little too harshly. Sometimes rightly, whatever. I at least am not clear that the police department has any sort of policy or procedure or training on how to handle somebody who's literally a bystander, so not involved in the actual event, and who happens to be taping the event. And I think that kind of incident will only increase, particularly with young people who all have phones and they can all videotape and everything gets posted everywhere. And they may not understand how by videotaping the officer engaged in a very stressful event, it may just increase the stress level on the part of the officer. And so they videotape it, and then when the officer says, please don't, even if the officer reacts the right way, and I don't know if that would be right or wrong for the officer to say, please don't, it just escalates. I think that we should look into the number of incidents where that happens and the kinds of factual scenarios that we've seen, and perhaps, without, again, commenting on any specific report, but at the very least encourage the police department to also look into and think about this kind of incident in action, because I think it's important, and I wouldn't want to see an officer, in a stressful event, essentially get angry at somebody for just videotaping and perhaps create another stressful event that results in injury or something worse. I think that there should be some thought on that, and we should perhaps encourage the department to look at that.
Wasn't there a case just recently argued in the Supreme Court about the cell phone? But this dealt with an alleged perpetrator.
Yeah, so I think that
The
case,
seizing of the phone of an alleged perpetrator.
that case, I think,
And I think they said they couldn't do an extensive search of the phone.
right, that was a little different. In that case, if somebody, I think, if the police department seizes somebody's phone,
Right.
the police department can't necessarily look in it for evidence without a warrant. I'm not sure exactly what the contours are. This is what I'm saying is a little different. It's somebody literally videotaping an incident as it's occurring.
I think personally, I think anybody can videotape. I mean, I think, Chris, you were around in the days of Tompkins Square Park when we had Patterson.
we litigated this thing 30 years ago, Tony, with the department, which I'll tell you about when I stand.
Okay, but we had it with Patterson in Tompkins Square Park when I was the CEO of that precinct. You remember, he used to videotape everything, and he was horrible at doing it because everybody was trying to didn't know how to plan a crowd. And I had to look at all those tapes.
Can I,
You know, there is a provision in the patrol guide, apparently, that covers this exact situation, and I'm quoting from a summary of the provision. It says, citizens are protected against unreasonable search and seizure in order to, citizens are permitted to observe and record arrests of other citizens as long as they do not directly endanger the safety of an officer, obstruct an officer's ability to administer his governmental duties, or are otherwise in violation of the law. And it's NYPD Patrol Guide Procedure 208-03, enclosure 4A-N. And so if there's no obstruction of governmental administration, and this is probably the result of what Chris Dunn is referring to, but it's in there.
I think it's great that it's in there, and I think it's probably obvious to some extent that people can videotape certain things. My concern is not whether or not an individual can do it, but how an officer in a stressful situation, I was never an officer, but I was a prosecutor, so I got to hear a lot about stressful situations, and I think officers sometimes don't, and while they're handcuffing somebody who's resisting and there's a gun involved, aren't thinking, oh my God, Patrol Guide Section 1.1E:2A, what do I do? Instead, like anybody who's being videotaped, and they don't necessarily want to be videotaped, they may react. And I think you can blunt some of that by significant training and just making them aware of better ways to react in that kind of situation.
But I think this issue comes up many times in situations where there is no stress. There shouldn't be any stress involved. It's a situation where an officer is giving someone a summons, and there's no gun drawn, there's no physical altercation going on. It's just it's a situation that should be routine, and all of a sudden somebody's recording it, it escalates where the officer is taking offense. And I think those are the situations that we're seeing occasionally in cases that we read as ordinary.
I can tell you, I mean, most officers' reaction would be, hey, you can't be doing that.
Exactly.
Turn that goddamn thing off. You can't be videoing this.
Exactly.
And if it's as stressful a situation as you described, he may go beyond that and push the guy. Hey, I told you, get out of here. You can't be doing that. I mean, that's the reality of it. But apropos to your comments, Jimmy, boy, what a timely comment. Look what happened yesterday in the West Village.
Now, I'm not sure I heard this
You didn't
incident.
you hear what happened in the West Village yesterday?
Oh, with our friend, the Hollywood actor. Or the
Yeah.
Yes, okay. Yeah, I haven't been under a rock completely.
We could do a policy review if the board wants.
Yeah.
We could put together cases. We could do a review of cases
Yeah.
involving
I think
videos.
there are lots of cases
Yeah.
that we could look at, yeah. I mean, there's plenty of them.
But that would be a reaction, clearly. On the part of the
Even in
officer.
my view is that a police officer even giving a summons, could be a stressful situation. I mean, a police officer giving a summons is still in an adverse relationship with somebody. They're handing somebody a ticket. It's not necessarily a fun thing for that person to receive. So I think in all situations, it can be very difficult. It's important to train these.
It always happens with paparazzi
Yeah.
and celebrities.
Exactly.
I mean, clearly.
But are you looking for cases where an independent person is videotaping it, or when the victim themselves, or both? That's fine.
I think both.
Okay.
Yeah, I think both.
Yeah, when you were talking, I made a note that it probably would be prudent for us just to kind of index how many video-involved cases that we have, and just kind of get some bandwidth on the particulars of those cases and see, but I also think that as police professionals, police department should have a knowledge of the patrol guide and know that in 208-03, enclosure 4A-N,
Exactly.
I think they should know that a citizen has the right to videotape as long as they're not obstructing the scene of the crime or interfering with the police protocol. So I would say that if for them to say, well, I don't know that number, no, they're police professionals.
Well,
I think it's more of a,
It's an emotional
I agree with
response,
you.
that's what it is.
I know it's an emotional response, but we also hold them to a high standard as they're interacting with the public and should know. I mean, this is not something that is, done, once in a while. I mean, and in the advent of social media and the continuum of that, that is something that should be in the forefront of their minds and know that they cannot come up to a citizen and just react emotionally.
I don't
I
think
think
it's...
what you're describing and what Dan described are two different situations. He's talking about a very heated situation where a bystander is videoing the police officer taking whatever action he's taking, and he drew in some
Well, but he
some
also
points that-
said that there were things that were videotaped that were not heated, that created a separate escalation.
I can tell you from my practical experience, most cops would respond by saying, hey, you can't be doing that. Get the hell out of here.
So they're violating Patrol Guide 208-3
Then
and motion for AM.
then you substantiate it and come up with a disposition.
I think that
That's why we're here.
I think it's not a matter of policy adjustment. I think it's a matter of more training. I think there's an opportune time to, at this juncture, to possibly communicate to the department that this area is percolating and that they should be reminded of that particular patrol guide provision. Whether or not every officer knows the entire four corners of a patrol guide, no, they do not. But this is an area, this is a category that they need some reminding. I think this is a very, very important point there.
Exactly, and this is something for the IG and us to have a discussion about. And let me just tell you something, they got a deputy commissioner of training, a new person over there.
Right.
That takes his job very seriously. He worked for me for many, many years. And this is the right guy to have in that position. And listen, I don't care how many times you tell cops about that. But by the way, just let me remind you, a lot of people think that thing is gospel, the patrol guide. Listen to what it's called. Patrol, that ain't the important thing. The second word, it's a guide. It's a guide. If you can memorize half of the stuff that's in that thing, boy, you're a genius. Believe me. Believe me, if you can regurgitate half of that stuff, you're a genius. But it's a guide. But Ben Tucker, who's the new deputy commissioner of training, he can tell them, he can have classes about this. They can do role playing about this. And I'm going to tell you what happens. You get out on the street and it happens, and that's going to be the cop's reaction, his initial reaction. I mean, that's for us to decide. That's why we have the Civilian Complaint Review Board.
Commissioner Martin raised a good point. I think we, at times, categorize things under the title of policy. When we recommend policy changes or suggestions, that's one thing, but this has come up a couple of times about identifying areas where, like to use your words, where there's things are percolating and bring that to the attention of the PD, and we've done that in the past in the form of memos. I think we all put that under policy, and I think that's what you were saying, Dan, because we've discussed this and I agree with you. But this raises what is becoming one of my pet peeves is that we've talked about this before, and I remember a meeting earlier this year or late last year where the board had asked for some sort of an outline of potential matters that we're seeing percolating so that we could assess that and decide whether or not we needed to submit a memo over to the PD. And I'm not sure if that fell between the cracks. There's a lot of things going on, but I just don't want these things to fall through the crack because this came up before. I'm sure of it. We've asked for something back to highlight some of these things that could be of issue. Where are we on that? Tracy, Marcos, I don't know.
We did submit in one of the board packets, I could go back and look which month it was, all of the reports that we have done, and then the reports that we were working on.
Right.
So that did
I remember
come through.
that. So where are we with the reports that were recommended on that? And look, I don't want to put anybody in the spot right now. Let's just, for the next meeting, if we can have a report on that.
Absolutely.
So we can move forward because, Mr. Dunn, I don't agree with a lot of things he says, but one thing that he did say that I agree with is part of our role is to address these policy or percolating issues, and we haven't done that in some time.
You know, if we get a permanent chairperson, one of their jobs could be to take those reports and disseminate it to appropriate committees to take a look at, to see if they need updating on some of that stuff. There's a lot of stuff we sent over to the police department, tremendous amount of stuff that we sent over. So the committee should be taking a look at that and make recommendation as to updating or any new thing. And this is certainly a new thing. By the way, the IG comes into effect next Tuesday. He's going to be on board May 20th. That's when his job starts. And we should have a lot of discussions with the IG, because this is the kind of stuff he'll bring back there, and I guess what he tells them probably holds more weight sometimes than what we say. You know, he can
Well, I
tell
hope
them-
not.
Well, he's the IG. I mean, so, you know.
I think Mr. Uri is very familiar with the operations of the agency because he was running the
Yeah,
DC
the
version of the
DC,
CCRB.
yeah.
So I think that that's a positive in our favor. I also think that in light of the legislation that the city council is proposing with regard to him giving quarterly reports on the law department, which we submitted written testimony on, the board, and I thank the board members and the executive committee for helping to draft the written testimony that we provided. I think that that's going to go exactly to what you were saying in terms of working with all the different groups more, the comptroller's office, the law department, and the IG, to kind of get those policy ideas out there, to see what we've done, to see where we should be moving forward, and then figuring out amongst the agencies how to best make those policy recommendations to the NYPD.
Is this something, because obviously we don't have a chair, and you know, another one of my pet peeves has become an issue, but do we have a committee that addresses this? Would this fall under the reports committee?
Well, I think the reports that we've sent over dealt with a lot of different areas, and I think for one committee to handle them all, I don't think that would be appropriate. It could be disseminated either the operations committee or the reports committee, or like we had established several special committees when we did the Hollow Point bullet controversy that was percolating. I don't know how many years ago that was with the Hollow Point bullets, and we did a report on that. So I think it would be up to the chair to take a look at it and then get those reports disseminated. And by the way, we got to get our committees back on track. I mean, I think we lost sight of some of those committees. You know, we haven't heard, and I think the new chair, one of the first things you should do is appoint chairs for those committees, and then if people are not willing to serve on them, just nominate people to be on the committees, and that's what we need.
I totally agree.
I don't know if you're being positive, Tony, or you're hinting at something that's about to happen regarding a new chair, but...
I wish.
All right, well, if that's the case, I don't want this to sit any longer, you know? I want us to keep moving these things forward, so I don't want to wait for a chair.
No,
I want us
you're
to
absolutely
decide
right.
if we're going to
I
designate
agree
a
wholeheartedly.
committee to help drive this along, because we have to keep moving forward.
Commissioner Grant, what we could do is send the board a list of, for example, we've been working on the iCards policy report. There are a couple of reports that we've mentioned in the past that we're working on. What we could do is send a list, send some drafts to the committee, to all the board members, and then they could, either the executive committee could designate people, or you could volunteer to be part of reviewing that report and then presenting it if the executive committee wants to create those special committees for people to be part of, as you said. It's something we can certainly send it to you guys so you can get a feel for what different projects we're working on, and then you could maybe perhaps designate members to
Right.
review it and oversee it.
I think it should definitely be sent to the full board, but I will recommend to my fellow board members that some folks volunteer or be designated to drive this, because it's going to fall through the cracks again. And a lot of us are working on committees. We're working extremely hard right now, and you know, you can't task the same people to do the same thing over and over again. So some folks need to step up and help to drive this through.
Sure.
Commissioner Taylor. One other issue that has come up very recently, the NYPD has now issued I don't know if it's a patrol guide yet, designation, but essentially those cases where the police are not supposed to collect condoms anymore in certain cases. I don't know if that's if the board has any position on whether they want to see that as an abuse of authority in cases where they do. So we may get cases now, and we actually have had cases in the past where the collection of condoms as evidence has come into play. It's not per se relevant. Before, it was not relevant to the allegations that we had, but now that it is a violation by the NYPD, is that something that you might want to consider as an abuse of authority? Or is that an other misconduct noted? It's something that we should talk about, and once we get a little more information from the NYPD about how they're handling it, maybe we can come up with some guidelines, because that might be an allegation now. That
I think you should wait, because the devil's going to be in the details.
Okay.
Yeah, I think it should just be case by case. I could see a situation where it's abuse of authority. I can also see a situation where, okay, so they grabbed a box of condoms, who cares? From an abuse of authority point of view, as opposed to a police department, violation of some sort of police department rule or district attorney rule.
But as an allegation, in terms of investigators getting a case, if the case came in today and that was an allegation, how they would proceed. I guess the investigations committee could meet and talk about
whether it's OMN or an abuse of authority.
Exactly, so that we would know how to proceed in terms of the closing reports and
sorry, I
recommendations.
misunderstood. Thank you.
But that's just a new item that just came up.
All right, we're moving on now to public comment, and we have a long list of people, beginning with and ending with Chris Dunn.
Good morning. I know it's been a long morning already. Mr. Grant, I will take you up on your olive branch. The policy stuff is very important, and I'm happy to hear you say that. And I don't know who you meant when you said some people got to step up, but you guys probably know who he was referring to, so hopefully people will step up. All right.
They know me. They know.
Well, I know. Starting with the symbolic, but nonetheless not unimportant, thank you for repainting. It's a small thing perhaps, but I do think that your public perception is important. I will say in conjunction with that, and there's a small thing, but Dan, I think it's an important thing. The business about people getting in here, it is just part of a larger concern that you've heard me say many times about public engagement between the CCRB and complainants and witnesses. And I view moving here, being in a situation where you've created actually more barriers. And I just think we have to get to the point where the public is easily engaged with you. And Tracy, you have talked often about borough offices. None of that has happened yet. And I just want to keep saying you have got to work on this. It reflects in the truncation rate. The truncation rate is just not an abstract statistical number. It reflects in large part how comfortable members of the public feel working with you. And it may come down a little bit because we've rejiggered the categories, and it may come down some because you're more investigators. But what's really going to bring it down is when you have a more open relationship with the public. And I know with respect to the APU report, I do want to say, I'm going to come back to it, I thought that was an excellent report. I appreciate you doing it. The APU report talks about videotaping access to the trial room to allow complainants who are incarcerated to participate in the trial. I think there was some discussion at some point with the board about the possibility of allowing a video connection for complainants, so they don't have to get their way down here to 100 Church Street and get through the security downstairs, and it's a lot easier on them. We just have to figure out a way to make it easier for people to participate in the investigation process. Right, with respect to the APU report, as I said, I think it's a terrific report. I encourage all of you to read that report. It raises some genuine concerns about the APU process and your relationships with the department, and I think the report is good in being candid in that respect. I don't know what it leaves out, but what I see, it looks like an open and candid report. One thing that struck me as being a particular potential problem is apparently the department's refusal to allow you to plead down a specifications and charges case. And as I understand it, but correct me if I'm wrong, basically the department says once you file charges and specs, you are on a trial track, and you cannot turn something into a lower level offense.
To be fair, that's the way the MOU reads.
The MOU actually specifically prevents that?
No.
I don't remember that.
No, it just says that we have substantiation with charges. There's no mechanism within it
Yeah.
for reduction. So it's something that the executive committee and the board is working on with DAO to
Okay.
work that out.
I'd be surprised if the MOU actually bars you from doing that.
No.
I don't remember that. My guess is the department's taking the position you cannot do it. And if that's the case, I hear you're saying you're talking to them, but that's a significant issue. And in no small part, that creates some perverse incentives in terms of the agencies preferring charges and specs versus something else. And I think it takes away some flexibility from the process. So there's that. The other thing is, and there are very few cases that have come through, looks like you're batting 0 in terms of the police commissioner adopting pleas that you have negotiated. Am I right about that? I think there are 3 cases, and as I understand it, in 2 cases, he has imposed a lesser penalty, and in 1 case, he increased the penalty.
Yes.
I realize it's a sample of 3 is 3. But I do think it's very important to stay on top of that, because the more the police commissioner is not adopting pleas that you have negotiated, obviously that undermines your authority in terms of actually being at the table negotiating pleas with the police officer. Okay, on the administrative closures, there was a much longer discussion about this at the Operations Committee meeting. I'm happy to see there was a board discussion about this. And what you're talking about sounds to me like it makes perfect sense. Truly, they are cases that are being generated without any complaint. But it does raise a larger issue about, and I am somewhat embarrassed even to say this, but I don't know the answer, about whether or not you can be proceeding with an investigation without a complainant, whether by charter you are required to have the complainant.
The charter only reads that we cannot proceed solely with an unsworn complaint.
Okay, well, there we go. It's the charter that says that. So, I mean, the concern that I have about the administrative closure cases is putting that case back into the pot, if you decide you should put it back in the pot, doesn't really advance anything, because you're not going to have a complaint that's going to come in. You're not going to have a sworn complaint that's going to get truncated anyhow. So I'm not sure at the end of the day that it's going to make much difference, but there's that. The docket, I noticed that we talked about this, the 18-plus month docket seems to come down considerably since the last month. That's great. I hope, I know you all take seriously, but I just want to say it again, just for the record. Those blown statute of limitation cases are a huge problem. You still have 4 cases where the complainant filed on time and they've blown the statute of limitations. And it's better than it was, to be sure, but this is something where zero vision should be part of the CCRB's mission. You should have no cases where you're blowing the statute of limitations. All right, mediation. I heard all the speeches about mediation. That's great. Tony, I was a little surprised because you said 2 completely contradictory things today. First, you said the heart and soul of what we do is investigations. And then you turned around and said we shouldn't be doing any investigations. We should be having hand-holding sessions with cops.
I don't think that's what he said.
That's my character.
Thank you for coming to his defense. That's not a contradiction.
Okay, see, there we go. He's not denying.
Hands not a contradiction.
We're going to have to work that out with him. Look, I get mediation. I didn't say there's benefits to mediation, but I've said this before and I'll say it again. When you do mediation, there's no investigation. You don't get to the bottom of what's going on. You get 2 people in the room. They have whatever session they have, and people walk away. And the agency learns nothing about what actually is behind the incident. And the agency can't use what's behind the incident. And going to the policy points, the most valuable thing beyond getting some sort of resolution for the complainant is you're figuring out patterns and practices, trying to talk to the department about that in an effort to make sure that doesn't happen again in the future, so you don't have fewer complainants. And I would love to have you have 0 complaints. But when you do mediation, you just cut off that possibility. And Tony, with respect to specifically the gun pointed, I heard your story, I get that. that doesn't translate to me into the notion that gun pointed is inconsequential for the complainant. And you may be talking about situations where cops may have many circumstances in which they pull out a gun and point a gun at you, and you probably have had a gun pointed at you. I have not. My guess is not too many other people here have. Jules, perhaps. Mr. Landon, perhaps. I am quite sure that for a complainant, in many instances, that is a hugely traumatic episode. And it is not appropriate, in my view, given the impact on the complainant, for that to be routed into mediation.
But what if the complainant wants that?
Well,
Right now, the situation, as I understand, is that if a complainant wants that, the complainant can't have that.
That's correct.
And
Just
we're
like
talking
if-
about dealing with the trauma to the complainant. So I think all Tony was saying was make
How about
that
the safety of the officer? That doesn't count? That doesn't come into play?
But Tony, that's a basis for not substantiating the complaint. I think in my mind, you're confusing the merits of the complaint
No,
with
I'm
how the
not.
complaint should be
No,
processed by the CCRB.
It's very clear in my mind that the weapon is a tool of being a police officer. And if I feel threatened, whether I'm stopping somebody in the middle of the night and I hold a weapon at my side, or I got it pointed directly into the car and there's 4 or 5 people and there's only 2 of us, I don't see that that's a contradiction to what I said before.
Okay, that's fine. I'm just telling you from my perspective, and I understand there's going to be a process. I heard what Jules said. There's going to be a process. You're going to have discussion of this. I'm just telling you, gun pointed, I think, is a big event for a complainant. I don't think that should be routed off to mediation. And I'll tell you, the reason why that is now non-mediable, you will go back, and I'm sure Tracy will pull it for you. There was a Times story about 4 or 5 years ago about a case where there was a gun pointed incident. There was a very dramatic incident, and the CCRB had mediated it.
I'm sorry, I didn't
The
hear that.
CCRB had mediated it. And the complainant talked about how unhappy he was about that. Big time story. And that prompted, as I recall it, a change by the board that those were not going to be treated as mediable cases. So again, it was a number of years ago. You'll pull it out. Maybe I've forgotten some of the details properly. There was a whole discussion about
I
it.
don't recall.
Yeah.
I had to be on the board.
You were certainly on the board. You might not have been here that day, but you were on the board.
I don't recall the case. I think I would remember that.
But I think your ideas are going in the same direction. The idea that the complainant initiates the idea of mediation, so that if they are so impacted in a negative way by a gun pointed, they wouldn't want a mediation, so we wouldn't send it there. And then if for some reason they would prefer mediation, they prefer the opportunity to address the officer in a mediation forum, all I think Commissioner Simonetti and Commissioner Gittner are saying is give them that opportunity, if that's their goal.
I think maybe you were ascribing a benevolence to a mediation offer by the CCRB that I do not ascribe to. Okay, I mean, you kind of view that when you guys say mediation to somebody, they're just sitting there going, oh, they're bouncing this or doing that. Was I sufficiently traumatized? I think for many people, they may think, I'm getting jerked around by these guys. I'm never going to get any justice from them. If that's all I can get, I will take it. And so I'm just saying that I don't think it's quite the dispassionate, logical decision made by the complainant to participate in mediation. And I think there are some categories of offense that you have all decided should not be mediable. Okay, so you have recognized there are some things where the complainant should not be given a choice. And I am simply saying that gun pointed is a category I do not think, for the same reason you don't give complainants a choice in other alleged misconduct, you should give the complainant a choice here, given the importance of a gun pointed. Now, I will say in conjunction with that, and I say this publicly, the department is very good in terms of shootings. Okay? The department is extraordinarily restrained when it comes to shootings. So I don't say this in the context that we have a shooting epidemic in New York City. We do not. But I think the gun-pointed episode is still very, very important. All right. What we do have an epidemic of is photography harassment. And you were absolutely right to be raising that. You guys should be looking at it. And Tony, I'm a little alarmed by your suggesting that it doesn't make any difference what we say. It doesn't make any difference how many times we remind cops that they can't do this. They are going to blow up at people who take out their cell phones and videotape or photograph things.
You're right. That's the reality of a situation as described by Dan.
I understand that. Well, Dan was talking about a variety of situations, but I can
Okay.
tell you, if the
But the
department
most dramatic
constrain-
one he talked about.
Well, no, I think you're, okay, look, there may be incidents where there's a whole lot of stuff happening and someone pulls out a phone and a cop has an instinct. I'm not quite sure why the phone should necessarily prompt that. If they're engaged with somebody, the fact that someone's 10 feet away with a cell phone should be the least of his or her concerns. But I can tell you, we get photography arrest complaints all the time. We sue the department regularly about photography arrest issues, starting with the patrol guide provision that Jim read is from a case called Black v. Cud that we litigated in the 70s. The department settled it. That patrol guide language has been in there. There have been at least 2 operation orders that have gone out in the last 10 years that I have worked out with the department about photography issues. And it just continues to be a problem. And I do think it is a training problem. I do think it is a sensitivity problem. I understand people don't like having cameras in their faces. But, you know, as I think Dan's suggesting, you know, in today's world, they're everywhere. And at some level, they have got to recognize that that's just part of the landscape, and it shouldn't be prompting any problem on their part. And it's not just they say people get out of here. People are getting arrested. We have 2 cases of clients who got arrested for photographing police activity. One is stop and frisk in Bed-Stuy. A woman is walking home, you know. They've stopped 3 kids. They're stopping and frisking them. She takes out her phone and videotapes it. She ends up in cuffs. And it happens all the time. So I think it would actually be very helpful for the CCRB to be saying to the public and to the department, you have an issue about your officers in terms of the way they respond to photography and videotaping. And here's some constructive things that you can do. I think Commissioner Brad would be receptive to that. I think everyone recognizes that's fully legally protected activity. And the trick has got to be to get officers to deal with the instinct that they have had about, you know, that sort of scrutiny. So I would encourage that. I think it's a very good idea. All right, thank you very much.
Thank you.
Thank you, Mr. Dunn.
Oh, actually, I'm sorry. Oh, I forgot. Dan, you mentioned the memo, the frisk and summons memo. So I've gotten 3 reports that there's a DOI investigation taking place here at the CCRB about how I got that memo. Is that correct?
That would be up to DOI. They wouldn't tell us.
No, I'd be very, whether they told you or not, Tracy, I'd be very surprised if you didn't know what's happening. I've gotten reports from CCRB staff that it is happening. So are you telling me you don't know that there's
I think
investigation
the
taking
answer
place?
is, if there's investigation, no one's going to answer that question. So you can make a comment, but nobody here is going to comment on whether or not there is a Department of Investigation, which by its nature is confidential.
Okay, but if there were no investigation taking place, Dan, I don't think there's anything confidential about the statement. There is no DOI investigation. Is anyone prepared to say there is no DOI investigation? Because I have been told by 3 different sources in the CCRB there is a DOI investigation about my having gotten this memo.
I think
Yes,
I
go
would
ahead.
have known about it if I heard it. I've never heard it.
Okay, I would have thought you would have known about it also.
I've never heard it.
Okay,
And for the record, I never heard it
And
either.
if I did hear it, I'd tell you.
okay.
I did not hear it, so news to me.
I heard about it from you earlier.
All right, very good. I hear what people are saying. We'll see. I don't hear Tracy saying, I don't know nothing about it, and if I did, I would tell you, but that's okay.
I haven't heard anything from DOI about an investigation.
Okay. Okay.
Sorry.
And they shouldn't be calling you.
I don't think that they would tell
They-
us. I think that's the
Absolutely
key.
not.
Okay.
It would have tantamount to an EEO complaint coming back to us.
Well, Tony, we can debate that some other time.
Well, they're not supposed to be calling us. I don't know anything about it. I've never heard it before until you just said it.
Okay.
But you know, it begs the question. So if we did, what's the problem? What's the issue?
What the issue is that there is nothing that is unlawful or improper about the fact that somebody gave me that memo.
Okay, so you made your comment, but why are you standing here in a threatening manner? Like,
No, I'm
you
not-
have to demand it.
I'm not
I don't
threatening
understand.
anything.
What I'm saying is, I think it would be a serious issue if the board or the agency, or frankly the city, were investigating people within the CCRB who made available to the public a policy memo about a significant police practice issue, namely the frisking of people in conjunction with summonses. And Dan, I was a little surprised by your comments because I do think the agency has to have a position about whether or not that is misconduct or not. And the memo takes the position it is not misconduct because frisks in those circumstances are permissible as a matter of law. So I think that's actually going to be dispositive of what
The memo is limited, the memo is one lawyer's opinion reading cases on an area of law of which there's no court decision deciding one way or the other. It's just one lawyer's opinion, frankly, a well-written memo, in the context of a single case. That's all it is, and it wasn't distributed. It's not, as you keep saying, some sort of recommendation to the board to adopt a policy. It's just not that.
I get that. I understand that, although it was distributed within...
It was distributed to you.
No, no, no.
It wasn't distributed to me.
No, but let me get rest assured, the one person who did not give it to me was the person who wrote it.
I understand that.
This got circulated within the agency. Other people had it. Okay? And the point is that what I'm saying is that even for that particular case, and you do this all the time, you make decisions about substantiated cases based upon your assessment of what is lawful or not, or what is permissible or not, for instance, under the patrol guide, which is, Tony points out, is only a guide, although cops who go through the trial room and get fired for violating the patrol guide might think it's a little more than a guide. But the point is, at the very least for that case, it takes a policy, a pure legal position. You read that memo, it's purely a legal memo. And I do think that it's not okay for the board simply to say, we're going to leave that to somebody else, because by virtue of the complaint, you had to make a decision about whether or not to substantiate that complaint. And that memo determined whether or not, I assume, no, it's nothing about the particulars of the case, that the complaint in that case was substantiated or not. So it does take a position.
Under
And
the
it's
facts
guided-
of that case.
Well, there are no facts in the memo, Dan.
Right, because you didn't get the entire folder. But under the facts of that case, the panel made whatever decision it made. And under the facts of another case, that panel or a different panel will make whatever decision it makes. And it may or may not be the same. It's a totally fact-driven decision.
Okay, well then I don't know what the point of the legal memo was, but I hear what you're saying. We'll see where it goes.
All right, seeing that there's no more public comment, this meeting is...
Wait a minute. Rich,
Oh, did you sign up?
Sorry, I did not.
that's okay.
Okay. State your name.
You got a
Sure,
ticket.
Nahal Zamani with the Center for Constitutional Rights. And that
Could you come up here so I can see it?
Sure.
Yeah.
Thank you.
And so that the stenographer could hear you.
Can you just sign the... I'd rather...
Thank you.
Thank you. Get some diversity here and some comments.
So I have some questions and maybe some comments in my first CCRB meeting, so I'm sorry for obstructing the process, but trying to participate in it. I wanted to know a little bit more about the APU report. I saw that there was about, is it just the 2 pages in here, or is it a longer report? I haven't checked your website from today.
In terms of the,
More than 2.
in terms of the
more than
process
2
here,
pages.
we'd be happy to talk to you about
Okay.
any questions you have.
Great. So specific-
Typically, this is a public comment where the public makes comments
Okay.
about what's happening with the board.
So, I haven't read the report in its entirety. I've just glanced over 2 pages, but I think it would be interesting to see it. I noticed that in the CCRB's monthly reports, just in the last month or 2, we've seen the modification of pleas by the police commissioner. It's been a small number, but I'd still be interested in finding out a little bit more. So to the degree that the MOU allows you to make any information about that more public, to get a sense if there's any patterns or practices in these modifications, it might be helpful to make that public if that's something that the board can do. For example, and I'm just speaking off the top of my head here, if our police commissioner of the NYPD were to be modifying pleas in which cases only the officers were white and always the complainants were black, and that were happening in 90% of the pleas that he was ultimately modifying, and that number was beyond 3, but something more statistically relevant, that might be something that we should know about as the public. So that would be just one example. So if that information could be, if it's not already in the report, made more detailed and have some more analysis made available, that would be great. And I do urge more consistent reporting on this modification of pleas if it does continue to happen.
That sounds like a question for the police commissioner. You're asking on modifications?
I'm asking on if you guys have information such as a written explanation.
Are you
or
talking
information
about
on the details of
placing
the case.
someone on modified assignment? Is that what you're talking
No,
about?
I'm sorry.
Modifying the recommended discipline.
Exactly.
Okay, do you also know that the police commissioner is the final arbiter
Absolutely.
of discipline
Yes.
in the police department?
Yes, as such.
Regardless of anybody else who has recommendations and adjudications,
understand.
he is the final arbiter.
Yes.
And by the way, I must tell you, a plug for the police commissioner, it has to remain that way, because I held that position. It has to be that way. Because in the military, it's the same way. The commanding officer has to be the person. And I know the whole issue about the cases of rape in the military, and I've been listening to on C-SPAN all those discussions. But there has to be, that the police commissioner has to be the final arbiter.
I think Commissioner Simonetti makes a good point, and in terms of right now we've only had 3
Yes.
come back. So we do annual reports, we do semi-annual reports. The executive committee and the board reviews them very carefully. There are FOIL requests that can be made with regard to obtaining information about cases. So that's a method by which you can proceed. But I think that as the year goes on and we get more determinations from the police commissioner, I think the board will be in a better position to decide in terms of what information we can present and how we can present it in the reports.
And I would just urge that the board, to the degree that it can through the MOU, make as much information public, just in case we're seeing an emerging issue. I think that would be really compelling for the public to have a really holistic understanding of what's happening. And that's, just given the scope of the MOU and agreement that you have, and any written explanations that you may have, or actually some detailed information about those cases, which you do to some degree, of course, identifying and lifting the identifying information, make public. If we can have a little more sense of what's happening here, that would be great, if it's not already contained in the report. As for the conversation around the new NYPD, and I believe it's a policy, but I do have to check if it's an order or not, regarding the collection of condoms as evidence, wherever this board may land, I think any type of consistent tracking that you can have would be really helpful, because there are times that the NYPD changes things that it does, either in the light of law or the consideration of the impact it has on New Yorkers, right? And then it doesn't go by that. That is, it doesn't trickle down to the behaviors and interactions that individuals have with officers. So if that is happening, any type of whatever you may land on, if you land on identifying as an abuse of authority in terms of tracking of complaints, whatever you do, if you can do that consistently, that really helps us ensure that this is not an ongoing issue, which it has consistently been, and with a particular disparate impact on LGBTQ people and individuals of color and transgender individuals, excuse me. And as you're conducting your policy review, proposed policy review regarding filming of individuals in police interactions, one suggestion may be, one comment may be to consider the escalation of either force or possibly misconduct in association with the presumed or actual filming of incidents. So that if individuals either being stopped by or interacting with law enforcement or others on the street are engaging in lawful filming of activities, are you guys seeing an escalation in misconduct? Are you seeing an escalation in the use of force? Are you seeing a disproportionate or incorrect escalation in the use of force? Therefore, someone filming my interaction with a cop 20 feet away has the cop react in whatever ways, but that reaction, whatever it may be actually thwarting the appropriate levels of force that are expected for that level of interaction. And lastly, I mean, this is more of a personal comment, but I can't imagine that if someone had a gun drawn on my face, or, you know, to my head as I was laying down on the ground and, you know, a boot presumably was on my neck, then I might automatically feel safe enough to go into a mediation. So as you guys are representing the interests of New Yorkers, a personal plea, and not for me as the advocate, but for me as the individual.
I did not suggest that.
Maybe just to
I did
consider.
not suggest that.
Maybe
This
just-
is not a drama course. This is real life stuff.
Sure, if I could just complete my comment.
Yeah, but please, don't take it out of context. You're talking about somebody pointing a gun in your face with his boot on your neck.
Sure.
That is not what I talked about.
So in cases of guns being drawn, it's not always a pleasant experience for whomever might be there. And so if you have individuals who are having a gun drawn on them by a member of law enforcement, by someone that is sworn in to serve the public, it can be assumed that they may not feel safe going into a mediation space, irrespective of how particularly stellar your mediation teams may be. So I just wanted to put that out there.
I just say, just so
Thank you so much.
clear, public understands, I don't think anybody was saying that if somebody gets a gun pointed at them and then makes a complaint, they're being forced into mediation. I don't think anybody suggested that.
My understanding was that you were talking about the possibility of opening up the opportunity for mediation should those individuals be
I
open to it,
suggested
right?
that, exactly.
Right, okay.
Not just be open to it, should
Yeah.
they
Yes.
choose it?
Yeah, and
That's
I think,
all.
you know, I think my feelings on that personally would probably echo that of Chris Dunn's in that, you know, it may not be something that is even felt like a choice because the experience may be so problematic and so traumatic for the individual that it might even have some ramifications on perceptions of your guys' ability to do the work that you're doing, the mere suggestion of it. So I just wanted
For
to
the
offer
public,
that.
if a person individually wants to accept that, you may not accept, but the other person might want to accept that.
Absolutely, yeah, and I don't
That's what the
want to, I only spoke
Tony
for myself, how I would feel if, you know, a gun was on me. I wouldn't want to make any comments about all of the public of all of New
been
York.
confronted with that?
No, I haven't, but I can imagine it's very nice. I have interacted.
Have you ever been shot at?
Excuse me, can I just say, are you finished with your public
Absolutely,
comment?
I tried to finish a
Let me
couple
just say
minutes
for
ago.
the record that, just so that no one is, you know, thwarted from giving public comment, the purpose of public comment is so that you can make public comment without fear of retribution or challenge. And so I want to thank you for your, is it Fanami or how do you pronounce that?
My last name is Zamani.
Zamani, right.
Yes.
Thank you so much, Ms. Zamani.
Thank you.
All right. This meeting is adjourned.